Can I offer some photos?
Those would have, I believe they would have to come through the state.
I believe they're photos of his injuries.
Of my injuries.
Show them to Mr. Davis.
I believe these look like the ones from Discovery.
The first 3 came from the sheriff.
Are some of these not from Discovery? Did you take any of these yourself?
My wife did, in the ambulance.
And I haven't seen any of these, Judge, if they're not from Discovery.
This moment right here is more important than it sounds. In criminal court, evidence doesn't just show up last minute. There's a rule called discovery, and if photos weren't properly shared ahead of time, they may never be seen by the judge at all. This isn't about hiding evidence, it's about fairness. And right now, the defense is signaling, we're not getting ambushed today.
I guess I would object to anything that I'm just looking at last second here.
What about the ones that were in the Discovery? It sounds like there's 3 or 4.
I don't even know if those were the ones that were in Discovery or not. I have no idea to know that. And again, his statement was that his wife took those photographs.
Mr. Schmidt is looking at the ones that he believes were in the Discovery.
I just had those printed off this morning at the sheriff's office.
I could double check real fast because they're all on a shared drive.
Your Honor, can I ask a question?
You're not supposed to ask questions.
Oh, okay. Okay.
But if it's something that you can talk to the victim witness coordinator and she can make a determination of what she thinks.
Okay.
It might take me longer than I thought. I forgot they took a lot of photographs of Mr. Morseth too.
All right, then if there's an objection to the court viewing the photographs.
Those are all Morseth.
And just like that, the judge shuts it down completely. No partial viewing. No cherry-picking photos. If both sides can't agree, the court sees nothing. This is judicial neutrality in action, and a reminder that sometimes procedural fairness outweighs visual impact, even when injuries are severe.
Then the court will not look at the photographs. All right, is there anything further? Okay, then you can step back.
Nope.
Thank you.
I did find them. They are from the Discovery, these first 3.
The ones from the Discovery, Mr. Davis.
I guess if we're going to do that, then I didn't know we were going to be submitting those, and I guess I would want to submit the photographs of my client, so he was all banged up and photographs too. I guess I would want to set an opportunity to show the court those as well.
Then the court will not receive any photographs. All right. Basis for the agreement reached, Mr. Smith.
Thank you, Judge. There are 3 main reasons why. 1, Mr. Morseth has 1 prior convictions from 2008.
What
2,
was it for?
It was for battery, and it was similar conduct to this with a family member. 2, he fully paid the restitution in this matter. I should note that the victim was made whole through the Victim Crime Compensation Fund. So this is money that go to the Victim Crime Compensation Fund, which is a finite amount of money that go towards other victims. So I do want to emphasize how important it is to replenish that fund. 3, this is a battery where both people showed signs of injuries. I think Mr. Davis would agree the visible injuries on the victim here are much more severe than his client's. His client mostly had bruises. There was a profuse amount of blood with this victim because of the 2 lacerations that required Dermabond to seal. To that end, they would be able to raise self-defense in this case. All he'd have to do is testify and say, he hit me first, which is what he told the police. Because of that, I think the court knows there's a shifting burden that occurs.
When you said he told the police, who told the police?
Mr. Morseth.
Okay, all right.
Because of how the shifting burden works with self-defense, where the state would have to affirmatively prove who struck first and also would have to show that the amount of force used was the legally allowable amount with the burden on the state using Blackstone's ratio, which is what beyond a reasonable doubt and presumption of innocence are based upon, I think this is a reasonable compromise. I should add that this was a case with no witnesses and no physical evidence as.
This is the heart of the plea deal, and it's not about mercy. The prosecutor is laying out risk assessment, prior history, restitution paid, and most importantly, self-defense ambiguity. When no one can prove who struck first, the burden on the state skyrockets. That uncertainty is often what drives cases toward negotiated resolutions.
To who started the fight.
All right, so you believe that it is in the public interest based upon all of those things that you have listed on the record?
Yes.
All of those reasons. All right. Mr. Morseth, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, Your Honor.
Did your attorney thoroughly go over this document with you?
Yes, Your Honor.
Did he essentially read it to you word for word?
Yes.
Do you understand everything on the document?
Yes, Your Honor.
Is that your signature on the document?
Yes, Your Honor.
It states that you are pleading guilty to a battery charge. Is that correct?
Yes, Your Honor.
You're 47 years old. You have 12.
You just heard a centuries-old legal principle still shaping modern courtrooms, Blackstone's ratio. The idea is simple but powerful. It's better for guilty people to walk free than for one innocent person to be wrongly convicted. That philosophy is why the state hesitates when proof isn't airtight, and why this case never went to trial.
Years of schooling, you can read, write, you understand the English language, no drugs, alcohol, or other medications, correct?
Yes, Your Honor.
No mental illnesses or disorders?
No, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
You're 47 years old, as I went over before. You have a criminal conviction, but only one conviction from 2008. Is that correct?
Yes, Your Honor.
And that is another battery conviction, correct?
Yes, Your Honor.
Did your attorney thoroughly go over your constitutional rights with you?
Yes, Your Honor.
They're identified on the first page of this document. Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that once you give up your rights, you can't come back and say, you know what, Judge, I want to have this. I want to have a jury trial.
Yes, Your Honor.
Do I need to go over your rights with you again, or do you fully understand them?
Yes, Your Honor.
You understand them?
Yes. Yes, Your Honor.
You understand them?
Yes.
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that the state would have to prove that on or around July 7th, 2024, in Burnett County, Wisconsin, you caused bodily harm to victim 1 by an act done with intent to cause bodily harm to that person without that person's consent? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand that upon conviction, you do face a fine of up to $10,000 and incarceration of up to 9 months or both?
Yes, Your Honor.
Do you understand that there's an agreement that's been reached where the state is going to argue for probation and a withheld?
Now the court zooms out, not just what happened, but who this keeps happening to. Prior violence, family context, metal objects, fear patterns. This is how judges assess future risk, not past guilt. Even when the law calls it a misdemeanor, the pattern is what determines probation, supervision, and restrictions.
Sentence, and your attorney is going to argue, or is free to argue, for anything the defense feels fit. Do you understand that I'm not bound to follow either of the side's arguments?
Yes, Your Honor.
I could sentence you all the way up to the maximum penalty today if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney, and in particular the section called the probable cause section, where it basically says what happened and why you were charged with crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you in fact did cause a battery to victim 1?
Yes, Your Honor.
and you did not have consent to do so?
Yes, Your Honor.
Are you pleading guilty because you are guilty of this crime?
Yes, Your Honor.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty, Mr. Morseth?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
I believe he did, Honor.
Did he look at the discovery and the evidence and talk to you about that?
Yes.
Did he discuss any possible defenses you have or a lack of defenses with you?
Yes.
And are you satisfied with his services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
Mm. Oh, Your Honor.
Then, as to count 4, battery, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of battery. The other counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think the court needs to place the defendant on supervision. I think what the court's heard today from the victim is extremely impactful. And I want to be clear. I believe that it happened the way the victim described it, full stop. However, I am not the plaintiff for Mr. Yeager in a civil case alleging a tort battery, which would be how you describe a situation where you go in front of a jury or a judge and say, hey, who do you believe? Do you believe Mr. Morseth or do you believe Mr. Yeager? I am the state, I'm representing the public interest, and I'm representing to the court about what we can know to 93% chance 10 guilty people go free is better than one innocent person being convicted, Blackstone's ratio. To that end, what I would say to the court is, because of the nature of his past conviction in 2008, albeit extremely long ago, the court should have paused to place him on probation still now. The reason for that is the 2008 conviction also involved.
This is the point of no return. A guilty plea isn't just an admission, it's the permanent surrender of trial rights. No jury, no cross-examination, no appeal on the facts. The judge carefully walks through this because once those words are spoken, there's no rewind button in criminal court.
Assaulting a family member. It was also involved holding a metal object. In that case, it was a pistol and a flashlight where he struck a family member on the head, causing head injuries. This is similar, very different object. The victim believes it might have been brass knuckles because he's aware that Mr. Morseth owns brass knuckles. He couldn't see very well, knew it was something metal. Mr. Morseth, when he was interviewed, said, I was holding my keys because he was changing the locks of that shed, and it was the keys he hit him with. So it's still a metal object either way. And because of the 2008 conviction, he should know how serious hitting with any metal object can be, whether it be brass knuckles or keys or a flashlight or a pistol. Because of that, and because of also, Mr. Yeager alluded to in the family, there's lots of concern about him that goes beyond the 2008 conviction, whether there's some allusion to it's not physical, but everyone's afraid of him for some reason other than physical. That's another reason for the court to have pause and wonder if there's anger management issues or if there's a greater domestic violence issue that needs to be looked at for Mr. Morseth. I know this isn't domestic violence because obviously Mr. Morseth has not lived with the victim here. But when I use the term domestic violence, I'm not using the statutory definition. I mean, violence against somebody in the family, which I think is probably the layperson understanding of the term. I think that the court's likely going to hear something to the effect, hey, judge, this happened in 2004. He's been on bond. He hasn't done anything since. So there's no need for probation. To that, I'd say just because he's been on bond doesn't mean he's been doing interventions, doesn't mean he's been doing MRT or thinking for change or cognitive thinking things that could benefit his family. And it doesn't give the victim the added benefit of at least some peace of mind that DOC will be monitoring him for this time. Thank you.
Thank you. Mr. Davis.
Thank you, Your Honor. Well, Your Honor, I believe it's a serious offense because it's a criminal conviction, albeit a misdemeanor. He's still not convicted of a misdemeanor battery. But when I look at, I've heard the victim, I've heard his position, I've heard the state's position, but my client has not changed the position one bit. My client did not start the fight, was not the aggressor. He was at his grandmother's farm. He had permission to be there, and no one had permission to put a lock on the shed. And the grandmother instructed my client to remove the lock, and he did so, and that really upset the victim to no end. And the victim was the one who started this, was getting in my client's face, and then the fight ensued. My client never had brass knuckles. He never had any kind of weapon like that or anything. The reason he had keys in his hands because that's what he was carrying, and as he was getting choked and beat, and he was fighting back, it would be the only thing that he had in his hands, metal, would have been a key or keys that he had, which he was out there with, but he wasn't using them as a weapon. He was getting attacked. I believe that my client could have stopped when he got the advantage, and I think at that point when he didn't, I think he even told the officer it was fight or flight. And I think his adrenaline was so much as that he continued fighting when he could have clearly stopped. That's the battery. He had no permission to continue on. It should have been ended, and they both should have gone their separate directions.